Every day in the USA, people find themselves in court.
Judge, Mr. Parker would ask that
You have four
he be
cases.
set for trial.
You have four cases here, Mr. You were Marvin Parker Jr. We're going to set the aggravated robbery first, and it looks like you have the indictment states 2 prior convictions in 2019. So if convicted of this one, you face no less than 15 years nor more than life imprisonment in that case. We'll try that one first, then the next one will be the third-degree felony of evading arrest, which is enhanced because of the prior convictions to, it looks like a third-degree felony is enhanced to second-degree felony punishment, and that's a minimum of 2 nor more than 20 years imprisonment. And then you have state jail felonies, which I don't. They do have the state jail felonies appear to have those 2019 convictions. So if convicted of those, you face third-degree felony punishment, no less than 2 nor more than 10 years confinement in prison, and fines up to $10,000 in each of these can also be assessed. But we're going to go on the first-degree felony first, okay? And that's what we're going to try. That's
One other thing, Judge, Mr. Parker, while he was in custody over here, was indicted by the U.S. Attorney's Office, went into federal custody, was sentenced by Judge Crone, and then has just recently gotten back here. I've provided Mr. Ham with a copy of the judgment on that. I just want to make the court aware because that's not anywhere in the paperwork.
okay. Well, sentenced for what? What was the crime?
Crime was possession of a firearm.
Oh, felon in possession of a firearm?
Yes, sir.
Okay.
Well,
Well, he's got. Well, how does that
I
make
believe
a difference
that
in this case? Does it matter? It can be used, I guess, in sentencing as an additional evidence for
he
sentencing.
also had theft of a firearm as one of the offenses in state court that he was indicted on. So,
We're going on the aggravated robbery first.
yes, sir. But I'm just pointing that out that there was the same firearm. It wasn't a different one. And Judge Crone, in her judgment, indicated that that was the only state case that she would run concurrently with her federal case. The other cases she would not run concurrently, even though there's been no sentence in the other cases. So it's a little bit different than the.
But does he understand that he's going to be held accountable in both jurisdictions? And you just add the numbers up, and it sounds like the way this is headed, you're going to be in prison for an awfully long time, the way this is headed. But that's your choice. We don't force anybody. Everyone here has free will, and they make their decisions. I'm surprised sometimes about some of the advice they're getting, but I don't think it's from the lawyers. I think it's from the people who think they're lawyers in the back. But every defendant has free will and makes their own choice. And I think it's wise to listen to lawyers who are appointed to represent you, since they take an oath to work in your best interest. But these will be, we'll start with the first degree felony, and then we'll go to the third degree felony in that order. All right, what else? I mean, there is no deal. This was the opening. This was the window of opportunity, but we got to set them. We're going to move forward.
So how would you say that though?
What?
So how would you say that I'm not guilty of these cases?
Yeah,
no.
You're presumed innocent, and you're not unless you're found guilty. You're not. But that's what we're going to do. But if you don't want to work it out, that's what the Constitution says. The jury gets to make the decision.
All right, I guess this is gonna go on because I'm not guilty of these cases.
We're going to go to trial, and that's what a jury gets to decide.
That's where we going. In.
All right. So what do you want to do next? What else?
Well, Judge, speaking with Mr. Parker
Yeah.
indicated he would like to go to trial quicker and therefore.
Is that right?
Request,
Yes, because
You would probably get to trial quicker if you agreed to release Mr. Grove, the next person on the trial docket wheel, unless you hire your own person. Can you hire your own
Judge,
person?
that's what I'm gonna do because
Well,
he got
what
no
you've been
evidence on
doing
these
for all
cases.
this time, you've been sitting there and he's been appointed.
was in
Don't
federal-
interrupt me. Don't interrupt. You can hire anybody anytime. And I would prefer that, but let me know because we're going to appoint somebody and the people pay and they're going to start getting ready, but we're setting this for trial. If you're going to hire somebody, get them quickly and then they can substitute. But if you want to get the trial quicker, I'm going to agree to Mr. Grove to be released. And the way the rule works is the next person on the trial docket wheel is going to be the one assigned. But you must have filed an indigent affidavit that says you were too poor and you needed a court appointed. That's the only way these people get appointed. Is that what you did?
You made me feel that
Well, you have
8
to.
months ago.
All right.
but I
It
think
says
the point,
zero income.
I think the point he was also trying to make, Judge, was he's been in federal custody during part of that time.
No, but some people, there are people who are in custody and they got access to money. And some of them. So that's why we do it this
Yeah,
way.
I'm gonna get my lawyer.
Well, until that happens, someone is appointed to represent you, but we're not lollygagging. We're moving forward for a trial quickly. Okay? Next person on the trial docket will be appointed, set this for trial. State, please get ready and we'll move forward on that case. That's on Marvin Parker and we'll try the aggravated robbery cause number 24 CR 374 first. 24 CR 2307 is now called the State of Texas versus Mary Catherine Roach. You are Ms. Roach?
Yes, sir.
Present with John West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, we can, Your Honor.
In summary, this indictment, ma'am, alleges that on or about October 18th, 2024 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. I guess it's a peace officer. Thomas Roberson was the complainant. Do you understand what you're charged with here?
Yes, sir.
This is a second-degree felony, which carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
My tablet's frozen. Give me a second.
All right, an agreement's been reached. Read it into the record.
10 years deferred probation, Your Honor.
Okay. You would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years. Is there a fine or restitution?
No.
Is that your understanding of the agreement?
Yes, sir. I just didn't know that I was having to plead guilty. I thought I was going to be able to plead no contest. I agree to this, to everything. Yes, sir.
All right. Do you know the difference between no contest and a plea of guilty? The essential difference is a plea of no contest has to be supported by other evidence. And that's done from time to time. But the real difference is a plea of no contest. This disposition cannot be used against you in any civil court. If somebody sues you out of this, then the plea of guilty is something that can be used in civil court of the same matter. And in no contest, then the civil court is going to have to potentially try the case and prove the case up. That's the difference. And if somebody hasn't sued you about this, then generally nobody ever enters contest pleas, no contest pleas, unless there is a lawsuit that's been filed. But that's
Understandable.
Yeah,
so.
it might take a while.
Whether you plead guilty or no contest, that is enough with State's Exhibit 1 to find that there is sufficient evidence to support a finding of guilt. Nonetheless, you've been there's an agreement that's been reached where you would be placed on deferred or unadjudicated probation, which means you would not be found guilty. So long as you followed the terms and conditions of probation. And if you do well, I shorten probation to 3 1/3 years, all the time, all the time.
Should have an judge.
If you fail well, your probation could be revoked. If you fail to follow these terms and conditions of probation, your probation could be revoked. You could then be found guilty and sentenced up to the full range of punishment. Do you understand?
Yes, sir.
I don't have anything in my file, in my pad. Nothing except these. There you go. Nothing's coming.
I know, understand, Judge.
And if I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
I'm working on it, Judge. We're having internet issues.
Guilty or not guilty? I say not guilty.
Ma'am?
Can I say not guilty?
Yeah, you can.
Yes, please. Oh,
Okay, she's just pled not guilty. We've set this for trial. We'll get it as soon as we can. He's talked to you about that. It's gamesmanship that's being played. There's really,
no.
it's guilty or
I
not
didn't
guilty.
understand. I plead guilty. If I
He's
get
talked to you.
probation.
I know he's talked to you, man.
Yes, sir. I
This
filed
thing
my
has been
disability in
around.
August, and I'm waiting until the end.
Do you want to do this today or not? You
Yes,
don't have
sir, I
to.
do.
You don't have to.
Yes,
We
sir, I
can
do.
reset this, but what we'll do is reset it for trial while we're waiting. We're not going to lollygag.
No, sir,
We're going to
please,
set it for trial
No,
and
please, please. I didn't understand. I filed my disability this year.
I'm using the English language that
Yes,
we
sir,
all
I plead
know.
guilty.
You need some time to think about it?
No,
though?
sir,
You
I
can go
plead
back
guilty.
and, no, and I'm not going to pressure you. We've
Yes,
got
sir,
other
yes, sir.
things to do.
I understand. I'm sorry. I plead guilty.
Are
Yeah,
you
I think she's
pleading
really
guilty?
nervous. She's exhibited a lot of very nervous.
This is
Look,
the last
everybody
time
ought to
I've
be
been-
nervous on this. They're looking at they're looking at liberties a lot of time in every case.
Aren't nervous.
So that's a constitutional right. And that's something that people ought to be considering gravely in each case.
But a lot of my clients aren't. She is very nervous. Every time I talk.
Have you ever been convicted of anything before?
No, sir. Just
Have you ever been charged with an offense before?
I have in the past. Yes, sir. I
Okay,
have
well-
taken off my record.
Okay, so you've been through the system. You know how it
I
works.
apologize.
That's okay.
Brain damage.
Huh?
I'm suffering with a mental illness.
Okay, hold on. Well, there we go. Well, she may not be competent to enter a plea. That's another thing. How do you know if you've got mental illness? If you're saying you've got a mental illness, how do you know you're competent? You should know, but a lot of people with mental illness aren't the best judge of their capacities. Do we need to have her tested?
Your Honor, under the standards of mental competency, she understands what she's charged with. She's been able to communicate with me, so I haven't had any reason to think she has any kind of mental issues. So I
We can delay this to get her tested if that's what we need to do.
you know, like I
What
said,
do you want to do?
he doesn't fit the
What do you want to do?
Plead guilty.
Are you, okay, is your mental situation in any way getting in the way of your ability to make a free, intelligent choice in this matter?
No, sir.
Okay, are you certain? Okay, all right. And Mr. West supports that from
Yes.
his interactions with you. Well, sure is a nicer pad here. Why do I have these kinds of pads? Y'all are hogging them over there. This is a pretty thing. This is bright and everything. It works. And this one works.
They thought you were giving you the nicer pad, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this again? That we've thought about it, we've talked about it. Final answer. How do you plead? Guilty or not guilty?
Guilty.
Are you pleading? It's almost like is that the right answer? Is that what you want to do
Sir.
after talking to your attorney?
Yes, sir.
Okay. Are you pleading guilty voluntarily?
Yes.
And because you are guilty?
Yes.
Okay, I'm going to show you what's marked as State's Exhibit 1, man. Did you sign that?
Different than yours. I got it, Your Honor. I know where to put it.
Yeah.
I can do it.
And you're where he's headed with that. Yes, ma'am. Take it. This is an important matter in your life and be deliberate. Okay. All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true at State, so help you God.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence reports, Wedge?
Yes.
You anxious to get out of there?
Yes, sir.
Is there anything else she has?
I need to go.
You'll be released today.
Thank you.
Hold on. I'm going to make the following findings. I'm going to see, this thing is just, you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. But I'm not going to do that. As long as you follow the terms and conditions of probation, you're going to be placed on deferred or unadjudicated probation, which means no finding of guilt, for 10 years. Do well, and that can be shortened. There will be terms and conditions of probation, but the probation office will go over with you. Please follow those. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to the full range of punishment, which is this. This is a second-degree felony. You're looking at up to 20 years in prison. You don't even want to think of that, except if it helps you do the right thing and make the right choices, think about it.
The probation will help me to be a good mother, to be in line.
The heavy lifting is all yours.
Okay, yes, sir. Thank you.
You have children
Yes, I have
they
7
rely on?
Yes.
Are you a good mother?
Yes, sir.
Well, then, good for you. Good for them. Just do good. Do well. And remember, the greatest gift you can give them is what? People don't go at Christmas time and, oh, I give them gifts and all that. What's the greatest gift you can give your child?
I gave him his life. It was very precious.
A good example.
Yes, sir. A good role model is what I choose to be.
That's what. Good for you, because that's the greatest gift, because it's a natural inclination for children to emulate what their parents do, because they have a natural, our Creator gives us all a belief that our parents are very special and they are influential on the way we act. So act well and they should do fine. And when you act well, you do fine. Okay. No, you can do it. I believe it. All right. That is all. Good luck, man. Thank you. Next.